afternoon. May it please the court, my name is Morgan Brungard on behalf of Appellant, the St. Martin Parish School Board. As you know, I'll be splitting my time this afternoon with my colleague, Mr. John Blanchard. I will be addressing the remedial jurisdiction arguments, and he will be addressing the unitary status arguments.
I'm going to ask you to please keep your voice up for my ears. But the problem is the acoustics in this courtroom every year seem to get worse. If you'll just turn that mic up and I can hear you.
Turn it up or turn it towards?
Thank you.
Is that better?
That's fine. Thank you very much.
It never hurts to speak loudly.
Yeah.
Except if you're trying to whisper. Okay, go ahead.
Thank you. In 2014, this court recognized that decrees in school desegregation cases are not intended to operate in perpetuity, and that the 1970 decree in this case clearly contemplated that the case would be dismissed in a matter of years, not decades. But because the 1974 decree was not a final judgment dismissing the case was not technically closed. And so this court remanded to the district court to determine whether the vestiges of de jure segregation had been eliminated to the extent practicable. A vestige is a condition present in the school district that flows from the original equal protection violation in the case. And of course, a court's remedial authority in school desegregation cases lasts only as long as vestiges remain. The district court...
How do you address the fact that the school board entered into a superseding consent order in 2017 or so, and that's what we're dealing with now? So to the extent that something had changed, obviously the school board thought not enough because they agreed to that. So how does that impact this whole discussion?
Of course, the consent decree was a tactical decision on the school board's part, but that agreement can neither waive the school board's argument nor stipulate to the fact that vestiges remain. And that's for two reasons. First, the vestiges determination in this case is a legal question that can't be established by stipulation. All the subsidiary facts regarding Catahoula Elementary School are undisputed. The town was rural and predominantly white. It needed a school, and so the students that attended that school were accordingly white. What is disputed is the legal ramification of those facts. So those facts are undisputed. What is disputed is whether those facts constitute a vestige over which the court has remedial jurisdiction. And that is a legal conclusion that cannot be established by stipulation of the parties. The vestiges determination is also not subject to waiver. This court's 2015 decision in Brumfield held that an order that is beyond the scope of the district court's continuing jurisdiction is void for lack of subject matter. Of course, subject matter jurisdiction arguments can't be waived. But even if one understands the vestiges question to be about the scope of the court's remedial authority, federal waiver rules still should not apply because the question goes to the authority of the court.
But it's not so much waiver. I mean, I get we can't waive subject matter jurisdiction. We've got to police it, as does the district court. But isn't it at least implicit in the superseding consent order that there are vestiges? And the school district agreed to it. It's not so much that the school district is stipulating jurisdiction or to vestiges, but, I mean, the court's making findings in the preamble of this order that says it's in the public interest, and if the school district fulfills these things, then it will have met its obligations. If it was already meeting its obligations, why did the district agree to that? And is that not resting on a finding that there are vestiges still to be remedied?
No, for two reasons. First, in that same preamble, the school board agreed that the measures in the consent order would remedy vestiges, if any. And second, there are no facts in the consent order that would support
that, if any, is for the future. I mean, okay, let's back up just a bit. In the history of America, we have unfortunately had issues of discrimination. There's kind of, maybe not just two buckets, but I'll talk about two buckets. One where somebody expressly says, no one of X race is allowed in this room, okay? That's very clear. Then there's also discrimination where basically no one of X race comes in the room, but there's just not a rule that says that. It just kind of happens that somehow, oh, everybody that has the wrong jacket or something doesn't come in, and it just happens that everybody with that jacket that they observe is somebody of a different race or something like that. That second category is much more predominant nowadays than the first category, okay? And so when you get to this issue of vestiges, the notion that, well, the reason why this school has a lot of white people is because, well, there's a lot of white people, that isn't enough of an answer, right? If that was enough of an answer, we'd still have a lot of problematic schools. And nothing is perfect, I understand that. This has been an issue for, unfortunately, decades, handling schools. But one of the issues that was addressed was this problem of schools that were only one race, and the busing and all of that. So there's been a lot of that over the years. So please explain what your point is, that it's just enough to say, oh, well, that's just how it is.
Sure. So the answer to your question comes from the Supreme Court. The Supreme Court, those two buckets that you described, the Supreme Court has said there's de jure segregation and there's de facto segregation. And de facto segregation doesn't violate the Equal Protection Clause unless it can be tied back to de jure segregation. And here on this record, there is no tie linking the present racial statistics at Catahoula Elementary School to the equal protection problem that was present in the 1960s. And we know that, for example, in this court's case, United States v. Texas.
But then why did you all agree to this order? If you're saying it can't be fixed because of where people live and it isn't our fault, and I know about de jure and de facto, but I'm not sure that's really where, as separate as you're making it nowadays.
Sure. The question,
Because it's a little more undercurrent than it used to be in the old days when it was quite clear laws were express. Now that's much more, as I said, under the surface.
well, keep in mind that the consent order did not agree to close Catahoula Elementary School. The district court has now closed Catahoula School, finding that it is a vestige of de jure segregation. The school district never agreed to that. And
Well, but let's back up from the closing of the elementary school. The school district did agree to benchmarks, variances, certain categories of faculty recruitment, student recruitment, graduation pathways. There were even a couple factors in there that are not enumerated in some of the tests. But the school agreed to these things, and the school agreed to benchmarks and variances. So why is the school doing that if there aren't vestiges to correct?
Of course, it was a tactical determination that the school district made. But that tactical determination cannot give the court power to close Catahoula Elementary School unless the school is a vestige.
Well, unless the school district misses the benchmarks and doesn't do enough, and the court made all these findings along these lines, and the court says, okay, what you've done isn't sufficient, so I'm going to order this. I mean, I guess ultimately what we get to here is, I know you're addressing jurisdiction, but where's the abuse of discretion in terms of closing the school or any of the other things the court ordered? But as far as jurisdiction goes, I'm just struggling as to why the district is agreeing to a series of remedial measures, but there's nothing to remedy.
Because the court,
If there's something to remedy, there's jurisdiction, right?
correct, but just because a party believes there's something to remedy doesn't mean that as a matter of law there is one.
Well, but the court did too. The court signed the order. I know it's a consent
Well,
order,
and
but-
we sent it back. So the original sort of reopening of this case was appealed to us in
Correct.
some form or fashion. And I was on that panel, and we expressly said that we are remanding to determine if the vestiges of de jure segregation had been eliminated as far as practical. So again, whether we call it buckets or we use the Latin words, the reality is we sent it back. We didn't rule that that's obvious. Oh, it couldn't be that anymore. We'll throw it out the window. We sent it back. And instead of y'all fighting that and saying, absolutely ain't no vestiges, you conceded to this consent order that suggests that there were vestiges that are being repaired by XYZ. Now, I understand you didn't agree to shut down the school, but that doesn't affect the jurisdiction of the court. The jurisdiction of the court is whether there is anything left to look at. Now, then the ruling on what there is left, that is, of course, appealable, but it's not so much a jurisdiction question as much as is it error or not question.
I see that I am out of time. Would you like me to answer?
Please.
So first of all, the question of vestiges is subject to de novo determination. This isn't an abuse of discretion standard because it's a legal conclusion. And the court must determine that there are vestiges for there to be jurisdiction. That isn't something that the court, that a party can stipulate to or consent to. And here, the facts on the record, there just are no facts tying the present racial statistics of Catahoula Elementary School back to the original problem in the 1960s.
Okay, thank you. And your colleague will now come up and tell us some more. Mr. Blanchard.
Good afternoon, Your Honors. John Blanchard on behalf of the St. Martin Parish School Board. To answer your question, Judge Wilson, my colleague, Ms. Brungard, expressed it, that the school board entered into a series of consent orders that led to the superseding consent order as a tactical matter. Desegregation cases can last a very long time, as we've seen this case is over 50 years old, and not entering into consent orders can be very expensive when it comes to this litigation. It was a tactical move on the part of the school board. But throughout the consent orders, the school board denied that there were vestiges of the prior segregated system still present in the system. As Ms. Brungard said, the prior panel acknowledged the 1974 order from Judge Putnam that contemplated that this case would be dismissed in a matter of years, not decades. Now, from that 2014 panel decision, we're now 8 years later. And
I think we all hoped in the 70s that we wouldn't be sitting here in 2020-something, 2022, dealing with these same issues still. But unfortunately, we are. Civil Rights Act was passed in the 60s. We are still dealing with these issues. So the notion that, well, a lot of time has passed, I guess there isn't any more discrimination, is unfortunately not true. I wish it were.
Yes, yes, Your Honor. I wouldn't say that it still exists in St. Martin Parish, but I would agree to your point generally that there is some instances.
Let me ask you a slightly different question. What is the basis for a conclusion that the school should be closed?
Well, Your Honor, the school should not have been closed because the St. Martin Parish School Board did exactly what it agreed to in the consent order.
What was the assigned reason and what's your quarrel with it?
Well, the assigned reason was that the existence of Catahoula is impeding the desegregation of St. Martinville schools. St. Martinville schools are about 68% black, a little over 10% from the goal, and Catahoula was a little under 10% from the goal, so they're on opposite ends of the spectrum. And the district court found that the existence of Catahoula impeded St. Martinville. But the school district did exactly what it was supposed to do in the consent order. They changed attendance zone lines. They reconfigured that school. And by the time that Catahoula was ordered to be closed, the demographics of that school were better than the parties projected in 2015. The parties projected the school would be 19% black, and everybody agreed to that plan that would lead to those demographics. At the time it was closed, the demographics overall were 23%, and for grades 2 to 5, it was 21%.
There's kind of two issues, though. Was there jurisdiction to do anything? Okay, is one issue. But then did the district court properly rule? That's what you're addressing now. That's a different issue.
Yes, Your Honor. I'm addressing the abuse of discretion for my argument.
Right, and so that is a little bit of a different issue than just whether a vestige could not legally ever be found in 2020, whatever, I guess at the time. That's different from, okay, so let's assume arguendo. There was jurisdiction. Y'all agreed to this consent order and so on. Now explain to me why closing the school is wrong.
Well, closing the school is wrong, Your Honor.
You were answering. I must have misstated it. We're in a time warp here. I've seen these cases long enough to be around when it was out. My question is, today on this record, given your compliance with these other provisions, what is the basis for sustaining an order to close that? The only arguable basis would be that it is linked back and tied to de jure discrimination. And pardon me, but that's 30 or 40 years linked back. And the school hasn't moved, and nothing else has moved or changed. I have a hard time understanding how you can sustain this.
Well, you agree with that.
Straightforward.
You know, he represents the school board.
I know he represents the school board, but I'm not hearing the argument.
Well, okay. Your Honor, I think the history of the demographics of Catahoula paint a clear picture that closing it was an abuse of discretion. In 1974, excuse me, in 1974, when Judge Putnam issued that order, Catahoula was 100% white. In 2015, 40 years where the board thought they were unitary before this panel's 2014 decision, or the prior panel's decision, it was 6.8% black. After entry of the consent order, and 7 years had gone by, that school was almost 1/4 black. The board has made tremendous strides in desegregating that school.
So that's your argument why we should at least overrule that?
Yes, Your Honor. When it comes to student assignment, that is my
But there's an additional fact that I'd like you to address too, that you omit in that, and that is simply that this case laid fallow. No one raised this thing for all these years. And then a district judge said, oh, that is an outstanding case on my court. And what about that? And it's been gone for 30 or 40 years. And they go into the archives and pull out this case. And then it starts all this and the argument that's back here. Now, I don't understand why today you can make, there's a serious argument that to correct this quote problem is if you're going to close a school, then not without complaint for 35 or 40 years.
Well, we completely agree with you.
Other than as an opportunity to.
There you go. That's a good answer. All right.
Well, I see that I'm out of time.
You've
Your
used
Honor.
your time. Thank
And,
you.
we pray that the court reverses. Thank you.
Okay, and your side has reserved their time, right of time for rebuttal. So Mr.
Sometimes you have to argue for them.
Jason, so you're here for the plaintiffs.
That's correct, Your Honor. May it please the court, Kevin Jason for plaintiff appellees, Tracy T. Borel and Genevieve D'Artez.
So what is your your best response to the notion that vestiges is a purely legal question?
It simply isn't. I mean, for one, this isn't a de facto segregation case. This is de jure segregation case. And ultimately, vestiges is a legal question that's premised on facts. Dowell in the Supreme Court, they determined that the question when dismissing a case, a segregation case, is whether or not the school board had eliminated the vestiges of discrimination. That's a question that the burden
Yeah,
falls
but
on.
I mean, de jure, there's not a law that says you can't attend this school if you are not a white person.
That's correct,
Okay.
but this case was never dismissed. This court decided that in 2014, that jurisdiction didn't end in 1974 and that it continued.
No, I mean, that's why I talked about the buckets instead of the wording, because you can have sort of an underlying essential rule, even if it's not in a rule that's written down anywhere that leads to this. But if there's not that, then their argument is a good one, that if there's not anything, if it's just that, well, everybody lives in this neighborhood and they are X rather than Y, what do you say to that?
Well, it goes back to the fact that this isn't a de facto segregation case. The fact that there was a finding of liability, finding of de jure segregation in 1965 puts this in a categorically different.
But what is the rule, what is the law under the current St. Martin School Board that discriminates against anyone based on race?
Well, for one, the court actually did make findings that there were discrimination against students, in particular in discipline.
Based on what? What rule?
It was based off of analysis of just the practices. I mean, well, what I'm saying is that there is ongoing discrimination. But to your question about,
So I'm saying the two are kind of related. I mean, again, nowadays, a lot of this kind of stuff is less clearly written down on a piece of paper. It doesn't mean it's not there.
I do want to emphasize the fact that this is a case of de jure segregation does ultimately create a different scenario and burden. With
How
Dowell,
is it de jure? I mean, again, Judge Haynes is asking you about what rule, what law, what ordinance says this race can't go to this school, this race has got to go to that one. I mean, where is that in this case?
well, it doesn't need to be established. So under the case law, there's no need to find ongoing discrimination, a case of ongoing discrimination, where a school district is under the jurisdiction due to the fact
Right,
that.
so we go back to 1965.
And that, yeah, exactly. And that finding ultimately imposes burdens and responsibilities.
Then why wasn't this dealt with in 1974? If the elementary school was there in 1965 and it's a product of de jure segregation, why wasn't it addressed in 74?
Well, ultimately, Your Honor, the question of whether or not a one-race school can exist in a school district is one that the school board would have to make a showing that it shouldn't, that it isn't a vestige of discrimination. And that's ultimately where, and that question comes up when the defendant tries to make a declaration of unitary status.
Well, but here, a district court found that the school district had achieved unitary status in 1974.
Respectfully, Your Honor, that was a different question. It wasn't to the unitary status in the meaningful sense.
So, yeah, we don't like that. We don't like the finding of unitary status, so it must mean something differently today. My point is that if this elementary school is an edifice of de jure segregation, why wasn't it addressed in 1974? Why is it suddenly de jure segregation today in 2022?
It was de jure segregation then. It was de jure segregation when this case was remanded in 2014. And
did anybody challenge the district court's ruling in 1974 that the school district had achieved unitary status then?
there was no question, respectfully, that the district hadn't made a meaningful, there was no question that the case had been dismissed and that the school district had met unitary status. In 1978, Judge Putnam even wrote a letter to the district attorney for the parishes, including St. Martin, where he indicated that this case was still under court jurisdiction.
Sure, but did anybody challenge the elementary school in the 70s?
I don't believe that occurred, Your Honor, but I don't think that was necessary, though.
The 80s?
I'm sorry?
The 80s?
No, Your Honor.
90s?
No, but I do want to point this court.
My point is this sat here for a long, long time. And if it's a vestige of de jure segregation by law, nobody challenged it till the teens this year? Last 5, 6 years?
I do want to, in 2018, this court heard Smith versus Concordia. And then that was a case where there was a consent decree. And in footnote 5 of that case, the question was whether or not the consent decree applied to this case and whether or not jurisdiction remained. In that footnote, it only questioned, one, whether there was a finding of liability initially, and then secondly, whether or not the school board had moved for a finding of unitary status and ultimately made the finding that vestiges had been eliminated. The reason why I point this out is because I think the rule under de jure segregation, just given the standards that were established in Freeman, in Swan, and other cases, is that ultimately the burden does fall on the defendant to demonstrate that it can be free from court supervision, and then can show that any racial imbalances are not based off of de jure segregation.
Okay, so what is the vestige from the 60s that continued on into the 2010s?
Sure, Your Honor. So for
What's your best argument on that?
So for Catahoula, that was a school that was built in an all-white part of the town to serve an all-white population. And it ultimately was keeping white students from black students. This court and other courts have made a finding that where the siting of the school is based is ultimately very tied to de jure segregation, and we shouldn't just dismiss the fact that the location isn't ultimately an intentional decision to perpetuate segregation.
Because, that gets back to my bucket analysis. So let me ask you this. What's your best case for the proposition that de jure does not require that you have an actual written down law by the school board or the state or whoever, the city, but that you are still discriminating as a matter of your essential law, even though it's maybe oral or unwritten? What's your best case for that proposition?
Well, Your Honor, there are several cases that post-date a finding of unitary status where a one-race school was still demonstrated to still be a vestige of discrimination. And I actually would just point the court to Swan, where the standard there is established. There is said that a one-race school ultimately presumptively raises questions. And in that instance, the school authority should demonstrate that is not a basis, is not a vestige of de jure segregation, even if it's not actively and practically separating people on the basis of race, even if it's...
Well, let me make a suggestion to you about the implications of your argument. You're familiar with the case of Fisher versus University of Texas?
Yes, Your Honor.
Under the underpinning of that particular program, call it affirmative action, whatever, by the University of Texas, was upheld by the Supreme Court. And and what was upheld was a rule that they adopted that in the upper 10% of your class, you are automatically admitted to the University of Texas. And that leaves only for anyone else, it's easier to get into Princeton than the University of Texas. But what that did was to change the admissions practices of that school. And what you're saying is that and that's based on the reality that we have a significant number of one-race schools. That's undeniable. And what the implication is, these are all the product of de jure discrimination. Until you reach into this large mass of people and find an unopened case, and not a case has been closed for years effectively, and use this to go back and to argue now for what? To go back to busing and to up to that basis. I don't understand your argument, the implications of it.
Well, respectfully, Your Honor, the implications are, I do want to tether them to what happened here. Catahoula was in the single zone within the school district where there were 2 elementary schools that were offering duplicate grades to the same population. Therefore, that is a hallmark of de jure segregation, where you have 2 schools that are serving populations, and then it essentially was differentiated by race. You had a white school and you had a black school. Catahoula, a school with a population that was dwindling, it was ultimately closed only after the school board was unable to desegregate the school through its other efforts. This was a decision that was done after other practical measures were explored, and ultimately, the court decided that it was the best and most effective means of desegregating the region. It wasn't just that there was a school with one all-white population of white students, but it did impact the students at the Early Learning Center and St. Martinville Primary. 1/3 of the black elementary school students in the entire district attended a racially identifiable school because Catahoula was an impediment to it. It was because of the fact that the school had been built in the de jure period, had perpetually and never deviated from being an all-white school, that the court did determine.
But what about the fact that it's now not all white?
Well, it is essentially still all white, in that it still is a very large outlier from the remaining schools.
Yeah,
it's
but
80%.
I mean, as Judge Higginbotham said, the sad reality is there are parts of the country where there's just not a lot of mixed races. And that by itself is not de jure. It's not discrimination to not require people to live in a certain place.
Well, that's correct, Your Honor, but I don't think we need to reach that far. I mean, in this case, this was a particular set of facts where the school was in close proximity to another school. I would also direct the court to look at the Cohen case, which was relied upon by the district court, where she explained why it makes sense and to ultimately close Catahoula in this instance. We're not asking that this court decide on every one-race school throughout the country, but just given the history of de jure segregation, given that the makeup of Catahoula never changed, and given the practicality of closing it, we are saying that it was not abuse of discretion.
So I look at this map. I looked at the map very carefully, and it's the location of the school itself. You have to one high school over here, and unless people move their residences, you're not going to get. You're going to have you can't do what you want to do. I mean, except by closing that school.
Well, I do see my time is, I do want to.
You solved the problem by closing that school and force them all to go over to the other school.
Well, one other unique factor of this case, though, is that the middle school grades for Catahoula had already been closed, and there had been success in having students who were based in Catahoula attend the St. Martinville schools for middle school. So here, it was essentially expanding an existing program where now the elementary school students could still bus with their older
Since you have limited time, I just want to get a clear answer to the question on this vestiges as a fact issue versus a legal question.
Absolutely, Your Honor.
Please sum up that for me in your view of it.
Yes, Your Honor. I do think it's a factual question. I think ultimately both parties are responsible for presenting their best facts, and then the court should make a determination. In 2014 and 2016, the defendants ceded their.
Does that then essentially agree to the fact question. So to the extent, I understand you can't agree to a legal question, but if you've agreed to the fact question that underlies the legal question, that may be enough, right?
Yes, that is
Okay.
correct, Your Honor.
Okay, thank you. And
Thank you.
we now will hear from the U.S. government.
Good afternoon, and may it please the court. Anna Baldwin for the United States is intervener appellee. Judge Haynes, I want to address the question that you've asked now about vestiges, and is that a legal or a factual question? The vestiges of discrimination is a factual question. When we're talking about jurisdiction in this case, the place from which the jurisdiction flows is the original constitutional violation in 1965. When this case was before the court in 2014, the court said that 1974 order did not terminate the district court's jurisdiction because there had never been an unambiguous factual finding that the vestiges of discrimination had been eliminated. So the case was remanded to the district court. And we're here again because although the board initially did move as a tactical, strategic measure, however they characterize it now, they initially did move for a declaration of unitary status as to student assignment, but then they withdrew that motion. They didn't insist on litigating those facts before the district court then.
So that's a concession of the facts by agreeing to a consent order that sort of tells them to do stuff now, right?
Absolutely, Your Honor. And the consent order, again, the consent order states in it that it reflects, quote, and this is at ROA 3873, the district's obligations under the United States Constitution. So, again, the constitutional violation is in 1965. The 1974 order didn't terminate the district court's jurisdiction. In 2016, the district said there are vestiges of discrimination that remain to be addressed.
So the de jure, the of the law, doesn't need to be present. It needs to just be vestiging still in 50 years later. Now, how do you address, though, what Judge Wilson asked about, which is, well, nobody said anything in the 80s, the 90s, the aughts, the 2010s, whatever.
So certainly, Your Honor, I think that the United States would agree, and I think the private plaintiffs would as well, and I'm sure the school district, everyone would have liked this case to be resolved much sooner. It would have been certainly preferable to the vindication of the rights of Black children in the parish for this to have been raised and recognized. But what we have here, the basis for saying Catahoula is or isn't a vestige, I want to separate that out into two questions. One, yes, there's a factual basis based on the district court's findings for finding Catahoula specifically is a vestige of discrimination. But regardless of that, and I'll talk a little bit more about that, the district court, even if Catahoula itself specifically had just to do only with geography, this is a district-wide constitutional violation. There are still 1/3 of Black elementary school students in the district are attending racially identifiable schools. So to address the vestiges of discrimination in St. Martinville and the Early Learning Center, the court could close Catahoula regardless, and the court was reluctant to do so and did so only after the other remedies had failed. So the court doesn't even have to reach, is Catahoula necessarily itself a vestige of discrimination? The point is, this is a district-wide constitutional
Then why
violation.
shut the school down? I mean, I'll tell you, I see a lot of y'all's side of the case, but the shutting the school down strikes me as having a lot of impact on a lot of kids. And how does that save the minority kids?
Yes, Your Honor. Well, first, just as of what issues are properly in this case, the school board only challenged the remedial jurisdiction as to Catahoula. They didn't actually challenge the shutting down that specific remedy under an abuse of discretion. I understand that they've argued that today, but that was not raised in their opening brief. But regardless, as to shutting Catahoula down, we have the district court made factual findings that Catahoula was cited for the purpose of serving only white students and for the purpose of segregating the races. That's a factual finding that is before this court on clear error review. And it's well supported by the record. There's 30B6 testimony from the
What year was that?
I'm sorry, Your Honor?
What year was that finding?
That finding was made in 2021, that the original purpose of the citing of Catahoula was for the purpose of segregating the races. And so that purpose continues onward. To Judge Wilson's question, what was happening in the 70s, the 80s, the 90s, the aughts? Absolutely nothing. There was no factual development that interrupted that ongoing fact that Catahoula was founded to segregate the races. And in fact, there's expert testimony, again, just to add a little bit more from Dr. Frankenberg, who is plaintiff's expert, asking, why some of the M2M program might not have worked, why, families might not have been comfortable going to Catahoula. And again, there was testimony that Catahoula historically was a sundown town, and so that there was still an issue with Black families not feeling safe in that community was certainly part of the record before the district court. But again, here, regardless of whether Catahoula, I think part of the difficulty that the board has relied on in their briefing is to say that there's some earlier finding that Catahoula just happened to be geographically cited, that's Judge Putnam's earlier finding from the 1969 order. And I just want to make clear that it's the United States position that there's no conflict between the 2021 findings about the purpose of Catahoula being for racial segregation and that earlier finding, because that was just limited to rejecting a busing remedy as constitutionally required. There's no earlier finding in this case ever made by the district court about the purpose of citing Catahoula in an all-white town.
But the purpose of citing the elementary school in 1960, whenever, pre-65, how does that mesh with today that the school's now, it's 80%-ish white, 20% black? Is that still a racially identifiable school? In other words, if the school district is using the building to try to achieve integration, again, why do we get to closing the school if the trend line is right? I don't know that the purpose in 1965, how does that bear on where we are today?
So when the case was back before the district court as of 2016 and agreeing to the consent order, Catahoula was only 7% black. And so it's as a result of the consent order, yes, and the boundary changes, it did become more
But isn't that evidence that it was working? And so shutting down the school would be an abuse of discretion?
No, Your Honor. The factual findings were that the attendance zone changes changed as much as the school was going to change, and that eliminating further racial identifiability at Catahoula, as well as at the St. Martinville Primary School, nothing could be done but for closing the school, that was going to immediately bring St. Martinville Primary within the threshold that the parties had agreed to as the desegregation standard. Again, the agreed to desegregation standard in the consent order, and that it would very nearly bring the Early Learning Center into that standard as well. So it was the entire zone. And as
So it's not just a question that an 80-20 school is racially identified, it's that this other school is still whatever it is, 95, whatever it is.
Yeah.
And it's racially identifiable.
Yes, Your Honor. It's in the entire St. Martinville zone, you have essentially still dual schools. Unlike the other zones where it's just one school, one grade, in the St. Martinville zone, you have a grade where it's predominantly white students, and 10 miles away, a grade where it's predominantly black students. And that's not going to further change absent closing of Catahoula to integrate the St. Martinville schools.
Okay, your time has expired.
Thank you, Your Honor.
We appreciate your argument, and we'll now hear from Ms. Brungard, is it? Rebuttal.
A few quick points on rebuttal. First, closing Catahoula did not bring either the ELC or St. Martin Primary within the plus-minus 15 goal. Those students still attend a racially identifiable school, and this demonstrates that the plus-minus 15% is a quota, not a goal. And quota.
What is your best case site for the proposition that the vestige question is a pure question of law, doesn't involve facts?
At best, it's a mixed legal question. And here, all of the facts, the subsidiary facts underlying whether Catahoula is a vestige are undisputed. It was a predominantly white town, needed a school, therefore the school is predominantly white. We all agree about that. And the question is whether that amounts to a constitutional violation. And that is a legal determination. Whether those facts are a vestige is a legal determination. And we know—
When you concede the vestige facts still exist by agreeing to a consent order, then that kind of answers a good part of the law.
No, we know under Swan and Freeman that the mere existence of a predominantly one-race school is not a constitutional infirmity if it doesn't flow from the equal protection problem. We must have that connection. And on this record, all we have is the mere existence of a predominantly white school. The town of Catahoula, on the record, was founded as a small rural village on the bayou. It was geographically and demographically isolated from the rest of the parish and was predominantly white. When the town needed a school—
So why not close the school?
Why not close the school?
Yeah.
Because there's no constitutional violation to fix.
Okay,
There's no—
why not close the school anyway? I mean, I'm not saying why should we affirm. I'm saying why not from you all's perspective, because obviously, and I respect that, you all are trying to bring this past the terrible past we have of discrimination. So why not do that?
As a matter of the board choosing to, or as a matter of the court telling the board?
The former. Why isn't it a good idea? Why are you still here fighting it?
Because the town, the school is very fundamental to this town. It is a small town, and the two pillars of that town are the school and its church. It's a big part of the local rural life, and the citizens of that town, the residents, care very much about having their school back.
Right, but back to, away from just why doesn't the board do it, the district court considered all that evidence and found that other evidence outweighed those considerations. We have to give a lot of deference to those findings. So where's the reversible abuse of discretion?
The great deference that this court owes is actually to Judge Putnam's 1969 finding that Catahoula's existence was mere de facto segregation. In fact, if consent attaches anywhere in this case, it's to plaintiff's 1969 consent to leave Catahoula all white. As was explained, there was a competing proposal from the United States Department of Health, Education, and Welfare that would bus black students from St. Martinville to Catahoula. Plaintiffs reviewed both of those plans, leaving Catahoula as it was, or some additional remedies to fix the problem, and they said those two plans are virtually identical and urged the court to adopt either. Judge Putnam then, and I quote, studied the school board's proposal and found that there was that the busing proposal was wholly unnecessary to remedy the constitutional violation, and that the school board's plan complied with the 14th Amendment and would de-establish the dual school system. If consent is anywhere, 40 years of uninterrupted silence should count for something in this case. One final point. The other side says that we have not argued, we have not challenged the appropriateness of closing Catahoula School, of Catahoula Elementary. That's untrue. We argued very strenuously in our briefing that the judge erred in denying unitary status on school assignment, or on student assignment.
Did you argue, though, that it was an abuse of discretion to close the school? Set aside jurisdiction, set aside unitary status, did you challenge that particular decision?
I believe so. I believe that's on pages 53 to 55 of our opening brief.
All right, well, you know, this is one we could spend days discussing with you all, but unfortunately that's not how appellate arguments work. We really appreciate both sides' arguments, and this case is now under submission, and this concludes this panel's live oral arguments. Thank you very much.